I'm going to introduce the two of us. So this very much is the Alison and Kizzy show, but our aim is to come to you with the legal update, changes in legislation and changes in the way things are being done legally in workplaces. I'm unfortunately going to have to ask Alison to be my assistant for the first part of this session because she is controlling the slides. So if we go to the next slide, we can see, and I don't know if I can actually get rid of this message. Yes, I can. So this is an overview of what we want to talk about to you today. And as I say, it's going to be a bit of a canter through some of the proposed changes and actual changes in legislation, and perhaps a little bit about how the Health and Safety Executive are approaching our current position on COVID-19 and the proposed changes to the fire safety and building safety legislation. Then we will talk a bit about legal approaches to wellbeing and mental health. And again, from the criminal side, we'll look at how the HSE are approaching mental health and their campaigns for good mental health and wellbeing, the international standards and how you implement those in your workplaces, and actually look at some of the claims that arise from stress at work and what is actually covered under legislation. And then we'll talk about the right to disconnect. Can we actually disconnect from work? How do we switch off from work when we're working at home? And we'll look at how they do things a bit more globally and compare them to how we do things here in the UK. Next slide. So what's new? And as I say, we're going to get through some of this quite quickly because a lot of it you'll be aware of and some of it you'll be quite tired of. And as you can see from my slide on COVID, I think we're all there really at the moment. It's quite difficult for us to progress and move forward in our home lives, in our work lives, when we know that there's still more coming when it comes to COVID-19 and our dreaded variants. So we're now at the stage where we're talking about Omicron and what that variant means for us when we were just about to return to the workplace and probably fully, or at least in some sort of hybrid way. The questions that I've been getting a lot about the variant has been, what impact is this now going to have on the workplace? Is it going to inhibit the way we return to the workplace or the way we work, the way we interact with our colleagues? Formally, there have been some changes. So thank God we didn't go back to immediate lockdown or even a fully fledged plan B. But what we did go to was to identify some changes in self-isolation upon travel and also face covering, the use of face coverings. So we've got self-isolation if you've tested positive for COVID and you're suspected to have had the Omicron variant, then close contacts will be required to self-isolate for 10 days, even if vaccinated. Also, thank God I travelled just before this, but at the end of November, we had issues with people who were arriving in the UK having to take PCR test at the end of day 2, again, even if you are fully vaccinated. So that's slightly different. The face coverings issue, we're back to, I think, where we were a few months ago, where it was having to wear face coverings when you're using public transport or in shops, post offices, banks, hairdressers and stuff like that, except if you are exempt. So how long are those measures going to last for? Don't know. I think the government are planning to review this again just before Christmas, just to see if we are managing to tackle the spread of the virus. I think at the moment, the numbers are still going up quite rapidly. And in fact, I think I was just telling Alison, they haven't ruled out a potential January lockdown because of the numbers at the moment. So what does that mean for workplaces and employers? Well, I think what it means is we're going to see more staff self-isolating because of being unable to attend the workplace because they may have come into contact with someone who has tested positive. It's that age-old ping on the test and trace app. What will hopefully happen is this reverting back to a true hybrid working, or even in fact working from home. So working at home if you can. And that's, I think, pretty much where we are. My only comment on vaccinations, and I won't focus on that because I could probably talk about that for an hour, but does it mean that Omicron will increase the likelihood of mandatory vaccinations? I don't think we're there yet, even with the threat of something that's much more transmissible. I think both of us probably have said in the past, it isn't advisable for employers to mandate vaccinations, probably except in very, very limited circumstances. But it is an area that I think employers need to monitor. They need to make sure they've got a vaccination policy, and look at whether or not there are issues around the type of activity that's being conducted. So those who work in care homes, those who work with vulnerable people, they might trigger the need for a potential mandatory vaccination because it's the best way of limiting risk. But it's something definitely we need to look out for. Next slide. Oh, is it not going? Okay, so I thought I'd put together a couple of comments on cases where we have seen some issues and fallout from the whole COVID approach to the workplace. We had the case, we haven't really had much in the way of prosecution or even in fact investigation that focuses solely on a failure to comply with COVID restrictions, but there have been quite a few bits of activity around this with the HSE. We actually in fact had the first HSE prosecution in September for a failure to have COVID steps in place, but it was in relation to other things as well. I've put a couple of cases on because they're quite straightforward and overlapped with the employment side of things. So Kubilius was all about an employment tribunal which held that an employee had been fairly dismissed because he refused to wear a face mask. Now, the background behind it was the worker was a driver and he worked for a company. He's worked there for several years, and he was dismissed about 4 years into his employment. He was responsible for making deliveries and going to client sites, and in fact 90% of his work was in relation to this particular client. He was very aware of the client's rules and regulations about wearing face masks for visitors, and he decided that actually he didn't want to wear a face mask. He continuously refused to wear a face mask when he was in the cab of his lorry, even with his window down, and he refused to wear a mask at their site. He had an employee handbook that said, you must treat the clients courteously, you will comply with what the clients say. And he just said, look, I'm not doing this. So after an investigation, there was a suggestion that actually, because he actively refused to wear a face mask and there was no real good reason why he wouldn't wear a face mask, he was dismissed for gross misconduct. And it's because the dismissal was deemed fair because actually all the rules that had been set out by government, by the client, and in fact by his own employer were very, very clear. So there had to be a really reasonable excuse as to why you wouldn't wear your face mask, and he didn't have one. And I think one of the key takeaways there is because of the policies being so clear, he didn't have a leg to stand on when it came to the dismissal. Rogers, very similar. This was a tribunal case which dealt with an employee who told his manager, I don't want to return to work. And I think that was a fear for a lot of employees at the time when we were on lockdown. When we eased back into the return to work, should I return to work because I still fear for my own safety and I'm actually not sure that my employer has the right systems in place to protect me? He didn't want to return to work. He said he had a vulnerable child at home and I won't return to work at this stage. The test there was whether or not there was a reasonable belief that there was serious and imminent danger from returning to the workplace. And because there were alternatives that could be put in place, it wasn't just you turn up to work and you're facing potential risk. There were other measures in place that could protect him in respect of his conduct of activity. So there was social distancing, there was using PPE, there was hand washing, he could section himself in an office when he was doing his work. So that because of the extensive measures that were in place by the employer, his dismissal was also deemed to be fair in the circumstances. I think what you should take away from that is the fact that policies and procedures being in place and being very clear at the time and also well documented and shared with employees, I think that was key to there not being an unfairness in dismissal. But I think it's only a matter of time. And as we've seen, the first prosecution has started to come through and there'll be more. What we will see is there's going to be a health and safety angle to this when the prosecutions start to come more thick and fast in the future. Next slide. I think I've put in something about the HSE next, which is, it's always nice to talk about the HSE, and I apologise if there are any HSE inspectors on here. I often get into trouble for saying naughty things about the HSE. But in this case, there's a lot of talk this year about the HSE's approach to COVID and what they were doing, and were they doing it well? And it just seemed as if there was not much activity when it came to COVID failures. So 2 prohibition notices, a couple of hundred improvement notices. Given the fact that there are a lot of deaths and there were a lot of people off work as a result of COVID related illness, it was said by the trade unions that the HSE weren't doing enough, and the way in which they determined a significant risk versus a serious risk, and serious would be in their determination, serious was actually less significant than a significant risk, if that makes sense. And it was said that you should determine it as a significant risk. Anything COVID related should be significant given the impact of the virus. The HSE, on the other hand, came back. So this was all discussed in a public forum, in a committee, all for everybody to see. If you're interested, you can go and look at it online. But the HSE came back and said, no, the reason why we haven't done as much as you think we should have done is because we boosted the presence of the HSE. We had spot checkers, we had people going around, and actually businesses were doing really well in terms of managing the impact of risk and mitigating risk. So that's why there's low enforcement figures, not because we were rubbish at doing our job. What they have said since then, however, is that they are going to look at reviewing their guidance on the website, particularly in relation to COVID issues such as ventilation, significant social distancing and PPE, and when these things should be used, and also the reporting of any COVID related risk. So we'll watch this space when it comes to that. Now, a couple of big changes that we have seen in the last year or so, in fact, what we've seen since Grenfell actually, have been the Fire Safety Act and the Building Safety Bill. They pretty much go hand in hand, and as I said, rather than going into any great detail on this session, I am just going to touch on some of the key parts of the 2 bits of legislation. So we've got the Fire Safety Act, which passed back in April. It's not actually yet in force, but what it does is it seeks to clarify the existing fire safety legislation that we have in the Regulatory Reform Fire Safety Order. I'm not going to say that several times. I'm going to say the Fire Safety Order in future, which talks about the who is responsible for certain parts of a multi-occupied residential building. So it makes it very clear, if it hadn't already in the fire safety order, that the building structure, the external walls and any common parts are the responsibility of the responsible person. And again, those of you who are familiar with fire safety will know that the responsible person is likely to be the owner, the occupier, the person in control of the building. It also extends it to the external walls, and the reason why it does that is because of Grenfell, because of the whole cladding issue and whether or not the responsible person should be assessing the risk for the facade of the building. So it's the doors, the windows in the walls, and anything attached to the exterior, such as balconies or cladding. And then it also includes a responsibility for the doors between the domestic premises of a flat normally and the common parts of the building. But again, questions have been raised as to, as we always have had, who is the responsible person? Can it be an individual? Should it be an organisation? And all of those are probably decisions that can be made by the specific organisation, but it's about who is in control. That's what we need to look at. Who is actually in control of the building, and are they assessing risk and mitigating that to as low as reasonably practicable? Part of that is going to include an update of your risk assessment. So as a result of this act, I would be expecting businesses to proactively review their risk assessments when it comes to their non-domestic buildings. Next slide. The Building Safety Bill, well, there's a lot in this. And again, for those of you who have even attempted to try and read the bill, or in fact look at some of the commentary that there has been about the Building Safety Bill, we are not going to be in a position to talk about this as an act or a passed bit of legislation until, I would say, mid to end of 2022. But it does cover quite a lot. And again, I will try my best to summarize this in the next sort of 5 minutes or 10 minutes. But it's a new set of regulations really focusing on those higher risk buildings, those big skyscraper type buildings, multi-occupancy residential buildings of generally 18 meters or more in height, or 7 or more stories, whichever figure is reached first. But what they're doing is widening the scope of what constitutes a higher risk building. And as you can see from my slide, we have set that up into 5 different parts. There's lots of different schedules that will accompany those parts to explain a little bit better what each means. Let me try and go through some of the key functions for you. So if we go to the next slide, I'll go through some of the key functions. The aim of the bill? Well, it really is to see if we can be more accountable. You will see the word accountability thrown up in a lot of different bits of safety legislation, probably in the last few years, but it is about accountability. There is no longer this need to have a company who is responsible for everything building related. They are actually digging down beyond that. And what I think the government and our regime wants to do is to hold individuals accountable for fire safety and structural building safety, because they don't want the likes of a Grenfell or a Lakanal House to happen again in the future. So there has to be some sort of accountability on an individual level. Which buildings are covered? Well, as I said, it's high risk buildings we're looking at, but I think some sections of the bill will have wider application. So high risk, generally high rise, and the 18-meter 7-story approach. For the purposes of design and construction and even refurbishment, we are looking at those buildings that have 2 residential units. Generally care homes and hospitals are going to be included. And if we are talking about the occupation of a building, yes, we are talking about residential only, but again, with 2 residential units or more. Who is responsible? So we come back to this idea of who is the responsible person. We have a bit of an idea of what the responsible person looks like by way of the fire safety legislation, but who is responsible under the Building Safety Bill? Well, it follows a very similar regime to the existing construction design and management approach, which again, many of us who are in construction or in property management will be familiar with the legislation. So it gives additional responsibilities to those duty holders in the supply chain, the client, the principal designer, principal contractor, and so on. But what, and I think I'll put that there, but what it also does is it adds new in occupation roles for those involved in higher risk buildings. So we now have an accountable person as well as the responsible person for fire safety. Accountable person is typically the person or the organisation that's responsible for the common parts of the building. When you've got a multi-occupancy situation, there might be more than one accountable person, and therefore you go back to the whole CDM approach, which is the cooperation, coordination and communication of all those people, and then you appoint a principal accountable person. You can see how it could start to get a bit complicated. They are primarily going to be responsible for the fire and structural safety of the higher risk buildings, and that includes making sure that you have this golden thread of information digitally held, but it takes you through the life cycle of the building. You also have this accountable person having to appoint a building safety manager. So the building safety manager is then responsible for the day-to-day management of fire and structural safety, and they prepare a safety case, which again contains information about the hazards and risks throughout the life cycle of the building. Next slide. What's the golden thread? Well, it's a golden thread of information about a building when it's created and how it's to be maintained. So it's to ensure all the people that are involved in that building, whether they are occupying, whether they are working on that building, have the right information at the right time to make sure that the building's safe and that risks are managed throughout the life cycle of that property. And what the bill does is it creates 3 different gateways at each stage of planning, design, construction, to make sure that the information that's required, the relevant information, is recorded correctly and stored digitally. And I've put the 3 gateways there. The only one we really need to worry about at the moment is gateway 1, because that's now in place. So those that are responsible for planning, you've got to have a fire statement to ensure that the fire safety considerations have been included in design proposals. And again, those of us who are familiar with CDM will ring alarm bells, because it will make you think of the whole designer approach, principal designer approach, assessing fire safety and general safety risks at design stage. And it does mirror this quite a lot. Who is going to govern this? Well, we have a building safety regulator who comes from the HSE, and they will oversee responsibility for compliance and deal with all the serious consequences that come with non-compliance. I think we have Peter Baker already in that role for the time being, who is, I think he's the HSE Director of Construction and Building Safety or something like that. He's got that sort of title. He is now in as being our building safety regulator, and the things that can be done, I mean, they're far reaching in terms of decisions being made in respect of design and construction. There's a regulation of the inspectors that are involved and building control approvers. They can issue stop and compliance notices, they can enforce, they can prosecute. So, there's a lot that the building safety regulator can do, very much akin to what the HSE can do generally within workplaces. And when is this all coming in? Well, as I say, I don't think we're looking at anything before mid 2022 because the bulk of the changes require consultation. There has been a lot of consultation so far, but I don't think we are looking at anything, this whole bill being enacted until 2023, but they are doing it bit by bit, and I expect there's going to be quite a lot of associated guidance that comes with this. And the question we get is, well, what should we do now? We anticipate this bill is going to be enacted at some point relatively soon. What should we do now? When you start looking at your buildings, you start looking at what you understand to be the potential risks for your buildings, given the fact that we know quite a lot about the provisions of the bill. And I think I've got a printout of actually the key provisions. If anyone's interested, I could probably email it to you. But identify which parts of the bill are going to apply to your buildings or your organisations, and how you could comply and positively, proactively demonstrate that you are complying. Set out a plan for compliance, deal with whatever those risks are, look at your existing risk assessments, amend if you need to. Again, it's looking at dynamic risk assessments and adapting to changes in the buildings that you have. I think we're going to see so much more in the next few months, and perhaps in the next year we're going to see statutory guidance come in, which is going to help us understand what we need to do to comply. So again, watch this space. Next slide. So that's kind of the big legislation that we are dealing with. I want us to now move on to the legal approach to mental health and well-being. And we have talked, I mean, I think the IOSH themselves have talked about mental health and well-being for such a long time. And I think a lot of businesses are starting to embed this properly into their businesses, into their policies and approaches to the workforce. Just next slide. And I think what we need to probably appreciate is the HSE have also done the same. So for many years, the HSE have tried to tackle things like work-related stress and had the stress management standards. And again, as much as I might say naughty things about the HSE, one good thing about them is their website is actually pretty good when it comes to some of the statutory guidance, and also on stress and their approach to that. And what they have done, and I'll come on to that in a minute, is they have highlighted that and publicized that in terms of a campaign that focuses on work-related stress and managing that within your workforces. But their previous approach, I think, was quite robust, and they had management standards that people could use and implement and integrate into their own policies, and give you some practical tips as employers on how to manage stress and how to reassure employees that they are being heard. It's about engagement, I think, engagement and consultation with employees. Some of the cases that we have seen will demonstrate that the regulators are increasingly examining the way in which employers are dealing with management practices and are responding to the way in which employees are saying, actually, we think there are some real safety risks here that will affect our ability to perform our duties. So what we've seen, particularly in the case of Renown, was the regulators' approach to say that you might have a holistic approach to health and safety and well-being, but actually, what are you doing in response to your employees and what they say. And in this case, this was a fatigue case where a worker had complained about fatigue and the ability to be able to perform their job, and Renown was prosecuted as a result of a failure to assess and manage workplace fatigue generally, because they'd heard it from a couple of employees, and they failed to enforce their own fatigue policies that they put in place. So it's really good having policies in place, but the fact you're not even using them or responding to what employees say in respect of your own policies is probably worse, because they're using your own policies and banging you over the head with it. There was another case that came out of Renown, which was Midland Red, and I think they were fined £2.3 million because of, again, a failure to act on the concerns of an employee. I think this was involving a driver, and he said that, you know, I'm not sure I should be driving in the way that I am. I'm doing really long hours, and I just don't feel that I'm able to do that. And it just fell on deaf ears. And the employer said, well, you know, you do have to still do your job. So we hear what you're saying, but, you know, we'd like you to continue at least until the end of this particular project. And what happened was he was allowed to continue driving despite saying he was fatigued. And unfortunately, he killed a passerby and a passenger. And it was significant because this is probably the first time that the regulator has taken into account fatigue or work-related stress as a result of then triggering a prosecution. So it formed part of the apparent risks that were in place, which then caused a road traffic accident. And I've had cases where the regulators have even considered corporate manslaughter as a result of a company's failure to respond to employees' needs and concerns, and the fact that they're overworked and not being listened to, or doing the job of 2 or 3 people. And yeah, the police have got involved, and I remember in one particular case, it was a corporate manslaughter investigation for 2 years. So it is something that definitely the regulators are looking at. The health and safety working minds campaign, I put a link here. I won't go into too much detail, but it's the first time I think that the HSE have re-invoked their determination to assess work-related stress and how you can do that, and how you can make tackling issues more routine and more embedded within your approach to work in the workplace. So if you're really interested in the way in which the HSE are doing that, they are working with a lot of really well-known businesses such as Mind, and working with other charities to make sure that this is something that is amplified within the industry. So have a look if you can, if you haven't already come across the Working Minds campaign. They are very supportive of work-related stress issues and managing that effectively. Next slide. And I think the last thing I want to say before handing over to Alison is really to look at the fact that we now have international standards that talks about psychosocial and psychological safety within the workplace. It's the first time we've had a global standard. We've had global standards for lots of things, but this is the first time that gives practical guidance and a bit of a set of frameworks as to how you manage as an organization psychosocial risks, and you embed better psychological safety to support your employees so they can work better, and effectively you'll get a better commercial environment if that's what the business is worried about. But it shows that you are focused much more on the mental health and the well-being side of health and safety, the softer side of health and safety, I sometimes call it, rather than just the physical health of employees. It's not meant to replace any existing initiatives that you might have, but it finds a way of tying together your existing measures with other things that you could be doing to prevent work-related injury and to promote better well-being at work. It's not another certification like our 45001, but compliance with this ISO will assist with ISO 45001 compliance. So I think it's a really good idea to look at this as businesses and try and see if there are ways in which you can take some of the ideas and implement those within your existing policies. And that's it from me in terms of well-being. I'll hand over to Alison now to talk about claims and how those have progressed over the last few years.
Okay, thanks, Kizzy. And yeah, it's good to be here. Good to see some of our friends from Chiltern and from the other branches. Good to see the new faces, and thanks for joining us. What I'm going to talk about, which relates back to the issues that Kizzy's also touched on, are claims arising from stress at work. So looking at how your liability might arise as an employer to pay compensation to somebody who might have become ill due to stress at work, and that might be due to increased workload, long hours, or bullying at work. So we're going to have a look at those issues now and how those duties might arise, and hopefully I'll be able to flag up for you some of the things you need to look at, or that might be indicators to you that your business might be at risk from some kind of stress claims. Now, Kizzy's already talked about the kind of duties that you have under health and safety legislation. And what I'm going to talk about, as I say, is the civil claims side. So whether your company might be facing a claim from an individual due to stress. So those claims are normally based in negligence. There might be other avenues that your employees could take. They obviously can, they've got the statutory basis for their claims, but there are also other claims that can be made in relation to illness at work, which is related to stress. And I'll touch on those at the end. But what I'm basically going to look at is those kind of personal injury claims that relate to stress. So you, as an employer, have a common law duty to take reasonable care of the health and safety of your employees in the workplace. And those common law duties are obviously in addition to all of your obligations under those health and safety legislation to take care of your employees. So you have that duty, and if you breach that duty and cause injury to your employee, and that injury is foreseeable, then you might be liable to pay that individual some compensation. Now, it's not just about the money. People often ask me, and I'm sure they ask Kizzy, what's the bottom line for the business in terms of monetary value of claims or prosecutions? But actually, thankfully, growing concern is now, and has been for a while, what's going to be the impact on the reputation of the business. There's always reputational issues. No one wants to see their name banded across, IOSH's magazine for having, individuals who are making stress claims against their business, but also impacts on the morale of your workforce. If somebody's making a claim for stress, those feelings often spread throughout departments and throughout the business, and that's not very good for the morale of the business. And sometimes there are also indications of more deep-rooted, more deep-seated problems within the business, stress claims, which have an indication that things might not be being managed as best they could. So these are in diagrammatic form, the different things that make up a stress claim. And we'll go through some of those now. So it will be for the employee to identify the breach of this duty of care, which gives rise to the injury. So your employee will have to show that this duty that you have to take reasonable care of them has been breached. Now, normally, the kind of stress claims we see, as I've already mentioned, relate to excessive workloads, long hours, or bullying. And you will probably see, if somebody brings a claim, they will be the basis for the breach of duty. Now, importantly, and I wanted to flag this, an employee is not required to resign in order to prove this breach of duty. So it's not going to be a defence for you to be able to say, well, they stuck it out. They didn't resign. It couldn't have been that bad then, could it? Well, actually, yeah, it could have been that bad. And, I've been struck over recent weeks. Every time I see the LinkedIn advert on the telly, I'm not connected to LinkedIn as in, I'm not advertising for them. But every time I see this LinkedIn advert on the telly where somebody says we shouldn't be in a situation where people are settling for job misery, for job security. And I think that's, that really resonates with me. A lot of people put up with a lot of really unpleasant working conditions, whether it's, excessive workload or long hours or bullying, because they need that job security, and people will put up with a lot in order to keep that money coming in the door. So I think it's quite right that, an employee is not required to resign in order to show that that duty has been breached. And there is case law that supports that. There was an individual in a recent case who pointed out there had been some management failings that were causing her stress at work. They weren't acted upon by her business, and she suffered some stress-related illnesses, and she didn't resign. And the defence that her company tried to run was that she hadn't resigned, so it couldn't have been that bad, could it? But actually, no, that's not the case. You don't have to resign. But on the other side of that, if appropriate support and monitoring has been given by a business, then you can potentially avoid this breach of duty. So I think many businesses now have support networks within the business, confidential call lines, and I think businesses are much more open to talking to their employees about their mental health, and people feel empowered to do that more. But if you provide that appropriate support and monitoring, then you might avoid this breach of duty. And that was borne out in another case where a teacher had suffered a depressive illness. She went back to work. The employer was obviously on notice that she did suffer from this a historical depressive illness. She had a relapse and made a claim against her employer, but actually they said the court held that there was no viable claim because the school had supported her and monitored her once she got back to work. So what injuries are covered? Well, as a matter of law, I thought it'd be helpful to highlight to you what kind of injuries are covered in what we call this kind of bucket of what's a stress claim. And I think when we think of stress claims, we kind of automatically think of psychiatric kind of injuries, and that's different to being just stressed at work, and I'll come on to talk about that in a bit more detail in a moment. But it can also be physical disorders. So physical disorders which manifest themselves as a result of stress, like ulcers and hypertension and heart disease, can also be the basis of stress claims. And that was actually approved by, in the case of Harding v. the Pub Estate Company. This was an individual who ran a pub in a particularly difficult area, and he said he wasn't supported by his employer in managing that pub, and he suffered a heart attack. Now, he wasn't ultimately successful in his claim for different reasons, but the judge commented in this case that it makes no difference that the injury that he suffered was a heart attack rather than a psychiatric breakdown. So that can be the basis of a stress claim. And that's borne out as well by the science. So for once, the science and the legal position are in step with each other. There was a recent survey or a paper which was published by in the Scandinavian Journal of Work and Environment and Health, and they found that they'd done some research and they found that there was significant associations between jobs of high stress and long working hours and coronary heart disease and depressive illnesses and strokes and such like. So I don't think that would be of any surprise to any of us, but a helpful paper to know about. Now, what amounts to psychiatric injury? Now, there's a difference in law and whether an individual is going to be successful in the claim between just being stressed, and I don't want to downplay being stressed at work, because I know everybody has probably felt like that from time to time, and actually suffering a psychiatric injury. Now, in order to bring a successful stress claim, an individual will have to have a recognised psychiatric disorder, and if your claim doesn't have that, then you won't succeed. Like in the Robinson claim, a lady said she had suffered a nervous breakdown as a result of stress at work. She was a nurse, but did not advance the medical evidence to support that she had an actual psychiatric disorder, so her claim failed. So it has to be a diagnosed psychiatric disorder. And as I say here, the point at which stress becomes a psychiatric injury may be difficult to identify, and these kind of claims will use medical evidence. We will look to the clinicians to make a diagnosis or comment that the injury that the person has suffered actually is recognised against one of really two recognised criteria: WHO have a international classification of diseases, and the American Psychiatric Association has a manual of mental disorders, and it has to really fall within one of those two recognised criteria. So common emotions that we feel from time to time at work won't be covered, but things like depression and anxiety and PTSD are likely to be. So once that's all established, and an injury, if there is an injury that has been caused, it has to be established whether that injury was foreseeable. Was it reasonably foreseeable? And every case will be fact specific, and every case of course is fact specific, because every particular instance will be different, the evidence will be different, the individual will be different. But really it's a question of whether the employee was put on notice and that employee was vulnerable or struggling or having some issues. And the court has commented that unless there's a real risk of breakdown, which you as an employer ought reasonably to have foreseen and averted, there can't be any liability. So that has to be foreseeable, and otherwise there won't be any liability. What I thought I would flag for you is some factors which are relevant to foreseeability. Now, these are things that the court will probably look at when assessing whether the injury was foreseeable. Now, these are not necessarily determinative of whether you will be liable or not, but all of these things will be taken into account. And I think each of these, when I look through these factors, they're all things that I think if you come across these factors in your normal working day and some red flags are being waved in relation to these, I think the more of these that you recognise in your workforce, the more likely you're going to have a risk of a civil claim against your company. So things that the court will look at are things like the nature and the extent of the person's workload. And I've just put a comment in here that exceeding the 48 hours in the working time regulations is not necessarily determinative that the injury was foreseeable. So if somebody is working in excess of 48 hours, that doesn't necessarily mean that it was foreseeable that they were going to be that there was going to be a stress claim, because some businesses and some lines of work do have hours which are far exceed 48 hours a week. But is that workload, so kind of then leads on to whether that workload is more than normal for that particular job, or whether the workload is particularly intellectually and emotionally demanding for that employee. Did that individual have unreasonable demands made on them compared to colleagues in comparable roles? And is there an indication that other employees with comparable jobs are also suffering harmful levels of stress? One thing that I always find comes up as abnormal levels of absenteeism. Is that person off quite a lot? Why is that? It might not be due to stress, but I know many businesses have procedures in place that if somebody's off a lot, they might meet with HR just to discuss whether, what are the reasons for that, and whether it might be relating to stress or something else that the business can support on. So that's another indicator. And I think more and more in the pandemic, organisational changes and cutbacks which increase levels of work. I think there's been lots of reports of businesses having to cut back during the pandemic, and particularly when people are on furlough, I heard reports of people saying, half of my team have been furloughed, but I'm doing all the work, there's still the same amount of work, and I'm having to support that. And I think even as we're coming back to work, maybe businesses aren't employing those people back again, and people are suffering increased levels of work as a result. So all of those things are flags. And then there's flags in relation to the employee, and this kind of resonates as well with something that Kizzy was talking about earlier about stress and mental health, and all being part of communication with people in the business. I think a lot of these factors relate to communication and support with employees in your business, and the openness and the empowerment of your employees to raise issues about health and mental health within the business and seek support. And if there is that communication breakdown, or if it's not there at all, if there's no procedures there at all, or worse still, as Kizzy mentioned earlier, I always find it's sometimes a worse situation where you have these procedures in place and that they're all beautifully on a shelf in a folder and no one's actually done anything with them. And it's only when me or Kizzy come in and say, oh, so what is your procedure of this? And somebody reaches up for their file and dusts it off and hands it to us, your heart sinks, because actually it means no one knows what it is, no one's been trained in it, no one's aware of it. So all of that communication with those in your business. But these are the flags which might be relevant to foreseeability relating to employees, whether the employee is given an indication that their health is at risk. Do they have a particular problem or vulnerability? Have they already suffered illness relating to stress at work? And again, absences, are there absences with them, or have their peers made complaints or given warnings about stresses that they're under? So all of that evidence will be going towards whether that injury was foreseeable. And you can bet your bottom dollar that the claimant's lawyers will be looking for this kind of stuff, and will be talking to the claimant's co-workers and seeking information from you as an employer about the processes you have in place to monitor this kind of thing. Now, in addition to all of that, if all of those hurdles are overcome, you still have to prove a causal link between the alleged workplace stress and the injury alleged. And I thought I'd just highlight these two cases, Dickens versus O2 and McLennan versus Hartford. In Dickens versus O2, an employee was promoted and she was unable to cope with the ordinary demands of this new role. She'd been promised some training and that hadn't been given. And she suffered psychiatric ill health as a result of that. Now, even though this individual had other contributing factors, she had IBS, she had some relationship problems, she was considered to be of a particularly vulnerable character, the court still held that the actions of her employer made a material contribution to her ill health, and therefore they were liable for the entirety of her stress claim. In comparison, McLennan versus Hartford, this lady was a HR manager who said that she had suffered a work overload, and that had made her have problems with her immune system, which made her more susceptible to infections and chickenpox and lots of things. And she said it also related to was a cause of her chronic fatigue syndrome. But in fact, the medical evidence failed to establish any causal link. She couldn't prove that, so her claim failed. Now, I thought I would just highlight for you the kind of damages that are awarded in these types of cases. These are the factors that the court will take into account. So when they're assessing damages, what I'm talking about in terms of these damages are the compensation that will be given for the stress element of the claim, so the personal injury element of the claim. There might be other elements, for example, loss of earnings and such like, but this is just for the personal injury element. And what the court will look at is now the person suffered this injury, how are they able to cope with life and education and work? How has this affected their family and friends and those they're in contact with? Is treatment going to be successful? Are they going to be vulnerable in the future? And what's the prognosis of this person? Is it going to get better for them, or is this going to be something that's going to affect them for the rest of their lives? And also, has any medical help been sought, and how is that going to help? And here is the kind of award ranges we're looking at. So from severe down to less severe. At the bottom, you'll see, for a less severe case, an award might be 1,500 in that, or up to 5,000. But in the more severe range, we're looking at, awards potentially in excess of 100,000. So in the more severe cases, we're looking at people who perhaps the prognosis isn't very good. They might not be able to return to work at all, or perhaps not in the same role or in a comparable role as they're in before. But in the less severe cases, hopefully that individual will have a good or better prognosis, and their symptoms won't be prolonged, and they might make a recovery. So that's the kind of range. So it's a very wide range, and it will be very fact specific. Now, are claims costly? Well, claims are always costly, contrary to what you might think, as a lawyer, once things get to litigation and get to court, you've spent the money 10 times over. So resolving things early is always the best option. But this came up on my radar last week, that there'd been some claims against NHS Highlands and an alleged culture of bullying, and the board reported settlements totaling 3.4 million for bullying claims recently. And so there's 150 claimants, and not many have been settled yet, but 2 claimants have been awarded between 60 and 95,000, and 61 between 5 and 15,000. Now, I don't know how those amounts are made up, and it could be that some of that relates to loss of earnings claims, but you can see how costly those kind of claims are to a business. And as I say, there are other types of claims. There could be breach of contract, Protection from Harassment Act claims, or Equality Act claims, which I'm not going to comment on today, but just to be aware that the claims might be framed in those terms as well. But there is some good news. ACAS did some research recently, and they reported that, depends, I know statistics depends how you read them, but I looked at this positively, that 36% of people who responded to their survey said that they'd seen a change to employee mental health and wellbeing support since the start of the pandemic. And I read that as being a positive change, and more than a third said it had got better. So, I mean, it depends how you read this, 9% still said it got worse and 50% said it stayed the same. But I see that as a positive thing, that, employees are looking to manage the stress of their employees and the mental well-being of their employees better. And as Kizzy alluded to, when I started working in health and safety, it was very, very focused on the kind of hard safety aspects of, machinery guarding and all kinds of things like that. And now more and more, we realize that, our people are our best, most valued resource. And as well as protecting their, physical safety, we need to look after them holistically as a person as well. And we're going to be more productive and happier and better workforce. So that is good news in my view. Okay, now I know we're up against time. So what I will do is I will just highlight this right to disconnect, because it was something that resonated with me, and I'm sure probably resonates with many of you, particularly since you've been working at home. Some of you might have been still on the front line, but since I've been working from home, and others that I've chatted to, we've all talked about being this kind of always on culture, that we're contactable all the time with our phones, our computers. Particularly in lockdowns. I must admit, I found it most tricky in lockdowns, because people know you're always there. You can't go anywhere else, right? You're stuck in your house, so they know you're there. You're not on a sports pitch or doing something different. So the right to disconnect really resonated with me, and I just thought I'd touch on our rights in relation to that. So there's an Aviva study you might want to have a look at, but I found this interesting, that Aviva did a study and found that 48% of people always or often check their emails after working hours, and 48% said they were troubled that work interfered with their personal and home life, and 52% thought the boundaries between home and work life were becoming increasingly blurred. And the result of that was negative impacts on both physical and mental health. It seems terrible that 66%, 65% say they often neglect their physical or mental health from being too busy at work. And I wonder whether too busy equates to doing stuff which is outside the normal working hours. And that was reflected as well in this study from the RSPH that said, people are, although we've got these kind of benefits of working from home and being more flexible, the impact of it is separating home and work life is negative. So just in the last few minutes, I'm going to give you a whiz around the world to where you might like to go and work if you want to disconnect. So do we have a right to disconnect? Well, let's all go down to Argentina. I don't know what the travel restrictions are. I do know somebody flew to Argentina on Saturday, but I think that was to avoid some travel restrictions. But in Argentina, you've got a right to disconnect from digital services outside working hours and during leaves of absence. And I know for a fact that this does work, because I worked on a case recently with an Argentinian lawyer for a big multinational company distributing around the world. And it became clear, and we discussed it, that he didn't respond to emails outside work hours. And we were working on a big case together, and he told me he was going on holiday and he wouldn't be contactable. He was going with his family. And we kind of went back to old school. He handed the case over to someone else in his office, and I dealt with that person while he was away. Everything went fine. And even though we're in different time zones, we managed to work efficiently together, scheduling meetings and calls and such like, at a time when we were both, or I knew he was in the office. I respected his his right to disconnect, even though we didn't call it that at the time, and it worked really well. So it does show that it can well, but I think it needs both sides need to respect that right. So same goes for Slovakia. There's a right to not to use work equipment during holiday and rest times. France and Italy have similar rights to disconnect, and there's a lot of emphasis on collective agreements in both of those countries, agreeing to how that's going to work, and the same for Spain. Belgium doesn't have a general right to disconnect, but employers have to consult with employees about disconnecting and such like. not so I would focus on one of those countries if you're thinking of moving. India, not so great that they had a right to disconnect bill that was proposed in 2018. They're thinking about it, but the bill didn't pass. So I don't know whether that's going to be picked up again. And in the Philippines, 2017, there was the Department of Labour announced that there was going to be a kind of a right to disconnect, but 4 years later, the legislation is not in place. Closer to home, in Germany, there's no legal right to disconnect, but companies are leading the way themselves with disconnecting policies. And Volkswagen and Daimler, for example, their servers don't send emails outside of office hours. And I have worked with some German companies, and I have been told in the last year or so, you can send your emails outside work hours or at the weekends, but we will not answer them. And they're big multinationals, and I kind of applaud that approach. But back to where we are today. So you've spent an hour with us at lunchtime, and you might have to work an hour later this evening, because also you don't have a legal right to disconnect here. But the TUC is calling for a statutory right for workers to disconnect and to have some communication-free time in their lives, and Prospect also support that. We had hoped that there would be some extension of protection of workers' rights in the Queen's speech and the mention of the employment bill. There was none of that, unfortunately. But at EU level, there has been a directive proposed for a kind of right to disconnect, so for member states to establish arrangements to enable employees to exercise that right, and sanctions for breaches of companies that don't do that. Obviously, we're not in the EU anymore, but if we're going to be working with the EU, which of course we are, we might see some consistent approaches across the EU and in the UK. And as I comment here, I think for multinational employers, there's going to be some challenges in terms of how you're going to ensure whether there's consistent policies across time zones and across jurisdictions. And as I mentioned earlier with my dealings with Argentina, I think it needs respect and understanding and buy-in. I think it particularly needs management buy-in and buy-in from colleagues across time zones. And I think it's easier if everybody in your country is doing the same thing, but it might prove more tricky if colleagues in America are expecting a 24/7 response to things, and you are disconnecting at 5 p.m. and that might cause some tension. So I think there will be difficulties, but and particularly I was thinking about people who work flexibly and might want to finish at 4 because they pick their kids up from school and then log on again at 8 o'clock and do 2 hours later in the evening. So I still think there's some challenges about what that right to disconnect might be, but I think we need to continue to examine it. I don't think it's an issue that's going to go away, and I think we're going to see more discussion about it. So just to finish off, I'll leave these with you because I know we're over time, but it seems counterintuitive to say let's disconnect, because we're always talking about connecting with people and talking, and it's always good to talk, I say. But I think it's important to talk to employees about empowering people to disconnect, making sure they create boundaries and literally switch off their computers, close it down, switch off their phone notifications, schedule after work activities. So, we're used to finishing work, saying goodbye to our colleagues, getting in our car or getting on the train. That's how we used to work and have that sign off. But now we don't have that. So I'll leave these with you for you to take to your employees and help them to disconnect. And hopefully next time we talk, there might be some movement in the UK on this.
I hope so.
Yeah. As I said, when poor Izzy was sending emails to me last night, which were nearly into today, I felt like we need to do some lobbying there, Kizzy.
I was going to say, I thought it was just lawyers that didn't know how to disconnect, but clearly it's a UK thing. But something needs to be done about that.
Yeah.
I might just go back. I might go back to our board right now, actually, and wave this European standard in front of them. I don't think I'll be thanked. But,
yeah, exactly. Let's see what happens. Yeah. Okay. Do we feel empowered to do that? Is the question. I think that's a.
I'll just say Alison said.
Alison said, "Talk to me." Yeah. Okay. Well. Yeah. So thank you to our IOSH friends for inviting us here today.
Listening to us. Yeah.
Yeah. Thank you.
Thank you, Alison. Thank you, Kizzy. That was fantastic. We have Kane, who will who's been looking at the chat and picking out some Q&As. We've got some time for a couple of questions. If we don't get around to your question, we will answer it and get it out to you in the LinkedIn post. So yeah, over to you, Kane.
Yeah, so question for Kizzy on the COVID front from Stephen Gascoigne in respect to managing people that have exemptions on face coverings. Do you recommend any processes, or is it reasonable that the employer requests evidence for this?
It's such a tricky area. I've had employers who have, I mean, they've tried to do it. Obviously, there's no requirement for the employee to provide medical evidence that they're exempt. However, it's a bit like the vaccinations situation, in the sense that you might say it will help better inform our policies and our approach to mitigating risk if you tell us why you're exempt, or if you are exempt, but you can't force them to do that. And I think the only way to get those things over the line is, as I think we've said before, is to engage better with them in terms of the development of policies and make them feel part of it, and therefore they'll be quite willing to share some of that information voluntarily. It's a tricky one. I sympathise.
Yeah, no, and all the soft piece that goes behind the back of the policy. Yeah, absolutely. Yep. Yeah, makes sense. Question in regards to the fire safety piece. Question from Tim in respect of how the building safety bill will interact with existing legislation. So from that side, I believe that the things like healthcare technical memorandas, or HPNs, or fire safety reform order. How do you see those integrating, or is it a case of it's going to replace supersede existing legislation?
I think the plan is for them to work together. However, they recognise there's a real problem with that, which is why the consultation continues. There's this overlap, particularly between CDM and the Building Safety Bill, and what the responsibilities are for the respective duty holders, and some contradict each other. So it's going back to consultation to decide how do we do that? Do we just have one set of responsibilities that supersedes each other, or it kind of mashes together as one set, or do we make sure that the two bits of legislation in particular work better together? So at the moment, we've got kind of two bits of legislation that run alongside each other as opposed to superseding each other, but I think we'll find that we'll get one set that applies to both.
I guess they will probably take a leaf out of the ISO standards, where they've done this holistic approach with 9, 14 and 40, and then
14.
Yeah, exactly.
That's right.
And the question over to Alison in respect to the wellbeing and stress discussion. John asked some questions regarding factors around determining excessive workloads, but you've picked them up nicely in your factors slides regarding emotional, what's normal and abnormal. So yeah, that was picked up nicely. Question from Leslie in respect of fatigue and FRI assessments. Would this be mandatory following any stress-related illness claim? Would that be applicable? Would you do a stress-related assessment for somebody post-claim?
You might want to do that when they come back to work. And in fact, one of the things I was looking at was when I was doing this, there was some commentary about whether if a business hadn't done a risk assessment in terms of stress, would that necessarily mean that they were going to be automatically liable? And the answer to that was no. But certainly when people come back to work, I think it's, we see with any injury, when people come back to the workplace, don't we, that, occupational health often have interviews with those individuals. And I think for a mental health injury, it's no different to if somebody hurt their leg. And I think we are, businesses and everyone is coming around to the approach that the two things are very shouldn't be treated differently. So I think if the approach that you take to assessing somebody who's coming back to work in terms of a physical injury should be transposed over to somebody who's transitioning back into the workplace with a mental health injury.
Yeah, that sounds great. And that holistic approach with HR and your health advisors, as well as the HSE teams. Yeah. And then the final question was regarding the right to disconnect piece. And you have to applaud the position of VW and Daimler. So yeah, that's
Yeah, great.
I'm in the wrong job, mate. I think I should be going on to them.
So a question from Tim. So if you disconnect, does your employer then have the right to sack you if you've disconnected, and you can claim that as unfair dismissal. I took from that as the UK position, probably not.
No.
No, and I think, I mean, I don't know what people's individual employment contracts say, but I know that, you know, particularly in my organisation, it says your contracted hours are X to X, and any other reasonable time that your employer requires you to work or something. And I suppose it's an interpretation of what that reasonable time is, and it might depend on what industry you're in, but I'm sure all of our employers could stretch what reasonable is in what circumstances. So no, unfortunately, I think unless you go to Argentina or one of our more relaxed European friends, we're kind of
Sweden. Tim's in Sweden. He's selling a really good story at the moment on the chat.
Maybe we need to go there. Yeah, but
Yeah,
no, there's no such luxury here in the UK.
Cool. Yeah, so that's all the Q&As. That's all the Q&A done from the East Anglian branch. Just to say thank you to see the familiar faces, and thank to Chiltern Branch for the collaboration on this day today. And yeah, thank you, Kizzy and Alison, for a fantastic update.
Thank you for having us.
Welcome. Thank you.
I'll hand back over to Luke.
Yeah, it was great to have you all here today. Massive thank you to Kizzy and Alison. Great to have Kane here and to work with East Anglia. Hopefully we can do more of these in the future, Kane, and work together as a couple of branches. It's really good. And yeah, thank you for everyone for coming along. We'll see you all soon.
Thank you.
Take care.
Cheers, guys.